South Dakota is one of the most landlord-friendly states in the nation when it comes to lease termination, and the process here is fast and efficient. The governing law is found in South Dakota Codified Laws, Chapter 43-32, the Residential Landlord-Tenant Provisions, along with Chapter 21-16, which covers forcible entry and detainer actions. Let's start with no-cause termination. For month-to-month tenancies, South Dakota requires either party to provide at least one full calendar month's written notice before terminating. The notice must be given before the start of the rental period in which the termination will take effect. So if rent is due on the 1st, and you want the tenancy to end on March 31st, you need to deliver notice before March 1st. Some landlords misunderstand this as 30 days. It's actually one full calendar month, which can be slightly longer depending on the month. For fixed-term leases, the lease expires at the end of the agreed term. South Dakota requires the landlord to provide written notice at least 1 month before the lease expires if they don't intend to renew, though this can be modified by the lease terms. If the tenant remains after the term expires and the landlord accepts rent, the tenancy converts to a month-to-month arrangement. For week-to-week tenancies, 7 days' notice is required from either party, and the notice must expire at the end of a weekly rental period. Now let's cover termination for cause, and this is where South Dakota really demonstrates its landlord-friendly approach. For non-payment of rent, South Dakota allows the landlord to issue a 3-day notice to pay or vacate. That's 3 calendar days, and it's one of the shortest non-payment windows in the country. If the tenant pays the full amount owed within those 3 days, the notice is void. If they don't, the landlord can proceed directly to filing a forcible entry and detainer action. Here's something that makes South Dakota even faster. The state does not require the landlord to give the tenant repeated opportunities to cure non-payment. In some states, the tenant can use the cure period multiple times throughout the year. South Dakota doesn't impose that kind of limitation on the landlord's ability to act. For lease violations other than non-payment, South Dakota provides a notice process that depends on the nature and severity of the violation. For violations that can be cured, the landlord should provide written notice identifying the problem and giving the tenant a reasonable opportunity to correct it. The statute doesn't specify a precise number of days for most curable violations, but courts generally expect the landlord to act reasonably, which typically means allowing at least a few days for the tenant to fix the issue. For violations that are not curable, or for situations where the tenant has already been given an opportunity to cure and the violation has recurred, the landlord can proceed with a notice to vacate and file for eviction without offering another cure period. For serious violations involving criminal activity or drug offenses on the premises, South Dakota allows the landlord to pursue immediate action. The landlord can issue a notice to vacate and file for eviction without providing a cure period. South Dakota courts treat drug activity and criminal conduct on rental properties seriously and typically move quickly in these cases. South Dakota also has a specific provision for situations where the tenant causes substantial damage to the property. If the tenant's actions materially impair the condition of the premises, the landlord can terminate the lease and pursue eviction along with damages for the cost of repair. One thing that makes South Dakota's framework particularly efficient is the speed of the court process. Once a forcible entry and detainer action is filed, the court issues a summons and typically schedules a hearing within a matter of days. The entire process from filing to judgment can often be completed in 1 to 2 weeks for straightforward cases. If the court rules in the landlord's favor, a writ of restitution is issued, and the sheriff carries out the eviction, often within a few days of the judgment. South Dakota also allows the landlord to recover damages in the same action. This means that in addition to getting possession of the property, the landlord can seek a money judgment for unpaid rent, damages to the property, and other costs, all in a single proceeding. This streamlined approach saves time and legal fees compared to states where the landlord has to file separate actions for possession and damages. On the tenant side, South Dakota provides limited but important grounds for early termination. If the landlord fails to maintain the property in habitable condition, as we discussed in our South Dakota habitability video, the tenant can provide written notice and allow the landlord a reasonable time to make the repair. If the landlord doesn't act, the tenant can terminate the lease. Active duty military members are protected by the Federal Service Members Civil Relief Act and can terminate with 30 days' notice following deployment or permanent change of station orders. South Dakota does not have a specific state statute providing early termination rights for victims of domestic violence. This is an area where South Dakota differs from a growing number of states that have enacted such protections. Tenants in domestic violence situations may need to negotiate with their landlord or seek assistance from local advocacy organizations. South Dakota strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove belongings, or take any physical action to force a tenant out. All evictions must go through the court system, and landlords who engage in self-help can face civil liability for the tenant's damages. One practical consideration for South Dakota landlords: the state allows landlords and tenants to agree in writing that the tenant will handle certain maintenance responsibilities. This flexibility extends to how the parties structure their lease more broadly. Because South Dakota's statutory framework is relatively light, the lease agreement itself plays an outsized role in defining the terms of the relationship, including the grounds for termination, notice periods, and cure rights. A well-drafted lease is your most powerful tool in South Dakota. South Dakota requires landlords to return the security deposit within 2 weeks of the termination of the tenancy, and the tenant providing a forwarding address, or within 45 days if there is damage to the premises and the landlord needs to assess repair costs. The landlord must provide an itemized statement of any deductions. This is one of the shorter deposit return windows in the country, so landlords need to act quickly after a tenant moves out. For the complete guide to South Dakota lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Landlord Tenant Law series.